This is the time scheduled for oral argument. In our case number CV130089, Pivotal, Colorado versus Arizona Public Safety Personnel Retirement System. Each side has been allocated 20 minutes for oral argument. If the appellants desire to reserve any time for rebuttal, you may do so. There is a clock in the podium, so you have to manage your own time. The time shown on the clock includes any time you've reserved for rebuttal. To assist you, you should be aware that we have read the briefs in this matter. We have looked at the pertinent law and cases and statutes, and we've conferenced it. So we're well aware of the facts and the legal issues involved. In addition, you should be advised that we are audio and video recording the argument. So when you approach the podium, clearly state your name and who you're representing. Finally, even though both sides have gotten 20 minutes, there's no requirement that you use all that time. If you're done and don't have anything else to add and we don't have any more questions, feel free to just say you're done. With that, counsel for the appellants.
Thank you and good afternoon. May it please the court. My name is Dan Quigley and I represent the plaintiffs' appellants in this matter, and at counsel table with me is my colleague Betsy Lamb. The appeal today presents a single issue for this court, and that is whether the Public Safety Personnel Retirement System, which I'll refer to simply as the system in my comments today, is a public entity for purposes of the Notice of Claim statute and the shortened one-year statute of limitations. If I do my job today, I will show you 3 reasons that compel the court to conclude that it is not. The first reason starts with the plain language of the statute. Second is that a construction that would find the system a public entity would render the 2006 amendments to the statute unconstitutional. And finally, the purposes that underlie the Notice of Claim statute simply are not implicated by whether or not the system is found to be a public entity. So with the court's permission, let me turn to the first issue, and that is the plain language of the statute 38384 that defines the system. And the very first words in that statute say that the system is an independent trust fund. Now, the word independent must have some meaning, and the common meaning is that it's free from influence or control of others. And the others here can only be the state. Now, what the system argues in its brief is no, that reference to an independent trust fund is simply an acknowledgement of the constitutional provision that provides that the assets of the state retirement systems are independent trust funds. That is not so, Your Honors. First, it would have this court assume that the legislature in 2006, when it included those words for the first time, was taking a superfluous and redundant step, simply memorializing what the existing law is. And under maxims of statutory construction, we are not to so assume. But second, the language in the statute is different than the constitutional provision. The provision in the Constitution says the assets of the state retirement systems are independent trust funds. In contrast, what the statute says is that the system itself is an independent trust fund. The legislature took pains to say that the system itself was independent. Now,
do you think the legislature in, I forget, 2000? Is this when that amendment was added?
2006, Your Honor.
2006. Could have changed the nature of the system? Do you think by its action in 2006, the legislature could have made it either an independent state agency, or if it was, not?
I think what it was doing is confirming what it intended all along, is that it was not a state agency, but that it was independent of the state. And it was doing so in part because of decisions that are discussed in our brief from 1986.
But I'm sorry, you?
Oh, go ahead.
But your argument would basically result in our saying that a fund or an entity that's created by the legislature, the governing board, which is appointed by the governor, which is public, the purpose is to administer the state obligated pensions, in which the legislature has specifically exempted from certain provisions relating to state agencies, personnel board, despite all those facts, this legislature meant that it's not a state agency.
That is correct, Your Honor. And with deference and respect, the legislature did not exempt the system from certain provisions otherwise applicable to state agencies. What it did was say very clearly in 2006 that the system and everyone having anything to do with it are not subject to the jurisdiction of the Department of Administration or any other state agency or instrumentality of the state. That is a much different statement than exempting. And if you look at the language, for them to have intended for the system to be a state agency, they would have had to accepted it from that language. But they did not. They were very clear that no state agency has jurisdiction over the system.
But in prior years, the legislature has come back and said, no, we're exempting this from, let's say, the Personnel Board in response to some of our decisions. Or we're exempting. Why would they have to exempt it? They could have just come up and said, it's not a state agency.
Respectfully,
Back
Your Honor,
then.
I think that's what they did. In 1986, the two decisions, the fund manager versus Department of Administration and the Superior Court, found that the system was subject to the salary recommendations of the Department of Administration and subject to following the procurement code in connection with hiring an attorney. What the legislature immediately did was not say, no, they're exempt from that. They said that the fund manager is not subject to the jurisdiction of either the Department of Administration or the procurement code. And it's a very different statement to say you're not subject to the jurisdiction than you're exempt from.
You know, one of the cardinal rules of statutory construction is that we have to interpret all of the words in context. And when I look at the beginning of subsection, I think it's still M, where it says the system is an independent trust fund. I have to go farther, though. I have to read the whole statute. And then the very last sentence, it says, as an independent trust fund whose assets are separate and apart from all other funds of the state. It seems to me that that's what the legislature was attempting to describe by using the words independent trust fund, which is, this is a fund filled with assets that are separate and apart from other funds of the state. It was not, that language, I'm having a hard time squaring that language with your argument that as a matter of statutory construction, the words independent trust fund somehow mean that the system or the plan is not a state entity under the claim statute, or a public entity under the claim statute.
Let me answer that in two ways,
Okay.
Your Honor, if I may.
Yeah.
As to the statute that defines what the system is, I agree you have to read it in its entirety to find out what the legislature intended. And that first sentence says that it's an independent trust fund, and its board, its administrator, its assistant administrators, and all its employees are not subject to the jurisdiction, basically, of the state. It said this Department of Administration, any state agency, any state department, or any instrumentality thereof. And I think the final sentence then that goes on to talk about the assets not being separate is just consistent with that. I think the legislature, by that language, is trying to make it abundantly clear that the state is, the system is independent of the state. Its employees, its assets, everything about it. Now, as to the notice of claim statute, the purpose underlying that is best described in a 2008 opinion, the City of Glendale-Yallen case, where it was clear that what the court was saying the purpose of that statute was to allow government to assess liability early and make decisions about whether to settle or not before litigation proceedings began.
Governmental entities.
And in fact, it uses the word government
I know,
throughout.
I wrote it.
Sure. And went on to say that it's an elaborate scheme to protect the public coffers. Here, the public coffers are not implicated in any way. The assets are separate from the state treasury. The aid system is self-sufficient. It gets no money from the state.
I think if you said that to the employers who contribute and to the employees that contribute, they might take issue with you on that, but
I think they would take issue depending on what the issue was before the court,
Well,
and whether
there's
they
that.
wanted to be
Yeah,
a
I
state
agree.
agency
Yeah,
for the
yeah,
purposes
yeah.
or not.
Well, isn't the policy of the, that the statute wouldn't the policy of the notice of claim statute be well served by applying it to the system here, given that the assets of the system are is the fund from which the government will satisfy its obligations to the plan members, its retirees. I mean, if the notion of the statute is you want to give the entity time to reflect and pay promptly pay claims, negotiate them to preserve the assets, wouldn't that be well served?
Well, respectfully, the system would be well served, but the purpose of the notice of claim statute would not, which is to allow the government that benefit. I mean, presumably, all of us would be well served to have a notice of a claim served on us in a very short period of time applicable to it. But the purpose of the notice of claim statute is limited to the government and allowing the government to
Right, but
assess.
of course, the state has an obligation to pay these pensions. I mean, and they're using this fund to do it. If the fund suddenly gets depleted by some judgment, then the legislature is going to have to find some way to refinance that, right? Which might come from state coffers.
Respectfully, Your Honor, I'm unaware of a legal obligation on the state to replenish depletions in the system's assets.
They've got to make sure there's sufficient funds.
Well, I think that's
That's not the issue before us.
That's not an issue
Yeah,
before
yeah.
us.
Let me get to the constitutional issue.
Sure.
Do we have to decide that? I mean, there's no claim that the statute's unconstitutional, right? You're just saying, it's just an argument that says, gee, if you interpret the 2006 amendment this way, it could render, it might make the statute unconstitutional, but there's no claim that the statute is unconstitutional.
You're correct, Your Honor. There is not a claim in this case that the statute's unconstitutional.
So we don't have to reach that issue.
Well, the reason it's relevant to the decision before the court is because it's a canon of statutory construction that you should interpret statutes in a way that's consistent with the Constitution. Here, interpreting the statute to find the system a state agency respectfully would have it unconstitutional because the 2006 amendment specifically said the fund is not subject to sections 5 and 8 of Article 9, which apply to the state. The only response from the system is, well, when the Constitution uses the word state, it doesn't meet state agencies. And that defies common sense, and it's been rejected by the courts who have held those provisions applicable to state agencies.
But why do we even take that up? The legislature has decided to tell us that the system and the board are not subject to the debt restrictions in the Constitution, Article 9, Sections 5 and 8. There's nothing in this case involving or implicating these sections at all. None of the claims asserted by your clients against the fund have anything to do with debt limitations, do they?
They do not, Your Honor.
Right.
And again, respectfully, it's just to show that the legislature, in drafting the 2006 amendments, which included those, was making it clear that this is not a state agency. Because if it was a state agency, it wouldn't have exempted it from, it couldn't have constitutionally exempted it from constitutional provisions that apply to it.
Well, I mean no disrespect at all to our elected officials in another branch of government, but there's been many a time in this state in which the legislature has enacted legislation that doesn't necessarily square with other provisions of state law. And I think, I thought your argument intriguing, but I thought it was reaching too far.
Well, but it seems to, I'm kind of getting back to a question I asked before, and which your answer, well, I thought your view is that statute reflects the legislature's view of the system. The legislature, in your view, would not have written the statute in the way that it did if it thought that the system was a state agency.
That's correct, Your Honor. And as we know, the best evidence of the legislature's intent is the language of the statute. That's where we start.
But having said that, the problem that I have is I'm not even sure that at this point the legislature can deem it to be a state agency or not. I think maybe from the get-go, from its inception, it either is or is not. And I'll tell you the problem I'm having with your argument is that, broadly speaking, it seems as if the system is a creature of the state. It was established by the legislature. The board's appointed by the governor. various statutes do apply to it. Some don't, but some do. And so I'm having a hard time getting away from the notion that it either is or it isn't, and that status probably was determined at the outset. So what can you tell me that would help me get by that, or what can you tell me about the inception of the system that would help me understand that it's independent and not a state agency?
I agree with Your Honor that it either was created to be a state agency or not. And I think the best answer I can give you is what happened in 1987 following the 1986 decisions when the court said it's a state agency. The legislature wasted no time in immediately taking steps to reject that and say, no, it's not subject to the Department of Administration. It's not subject to the procurement code. And then in 2006 made it even clearer when it included the independent trust fund language and the statement that it was not under the jurisdiction of any agency, department, or instrumentality of the state.
It's kind of like a whack-a-mole in your sense. The legislature has to respond to whatever occasion that comes up where a court or in its view misinterprets the status and will deal with that particular aspect of misinterpretation as it did in 87. Your view is it hasn't enacted a statute broadly that says the system's not, the notice of claim statute does not apply to the system simply because it hasn't come up.
That's correct. No court has considered whether or not the notice of claim statute applies to the system. That is correct. And I would respectfully say the legislature could have made the court's job very easy. It could have said, no, it is a state agency, very easily.
Or it could have said, it's not a state agency for purposes of the notice of claim statute. I mean, it could have just done that.
It could have done that, but that wasn't the issue they were addressing, Your Honor. They were addressing.
I understand. Okay.
And I believe that's what they did when they said it's an independent trust fund not subject to the jurisdiction of any state agency, instrumentality, or department. Unless let me make one final point, then I'll reserve the rest of my time for rebuttal. The Salt River case that we cite in our brief talks about charter schools. And in that case, it concludes that although charter schools have been held to be public entities for purposes of the open meetings laws and the public records laws, you don't go from that conclusion, say it's a public entity or state agency for all purposes. You have to look at the purposes of the particular statute that you're looking at. And we would submit here, if you look at the purposes underlying the notice of claim statute, even if you conclude that the system is a state agency for some other purposes, you don't have to conclude so for the notice of claim statute. And given that the policies of the notice of claim statute, in our view, are not implicated here, we would ask that you do so. Thank you very much.
Counsel, before you begin, I just want to clarify something. Did you all sign in, have a sign-in sheet that you signed in beforehand? Okay. Thank you.
May it please the Court, Michael Sullivan from the law firm QTAC Rock on behalf of the Public Safety Personnel Retirement System. PSPRS is a state agency. It's been recognized as a state agency for almost 30 years. It was acknowledged as a state agency in the McLeod case in 1993 by this court, in the Board of Regents case in 1989, and in two decisions in 1986. This court's reviewed the statutes applicable to PSPRS and determined that it was a state agency based on those statutes. Those statutes are still in existence and still apply to PSPRS. Nothing has changed. In the ADOA court, the court concluded that it was a state agency based on the fact that its board is appointed pursuant to 38848 by the governor, that the appointment of the board is pursuant to ARS 38211, which is for the appointment of state officers, which makes each board member a state officer. Its purpose is the management of funds received from public employees and from public employers. The Attorney General is the legal officer of the state of Arizona and its agencies, and it is the legal officer for PSPRS still. And the fact that the sunset laws apply to PSPRS, they still apply to PSPRS. Likewise, in fund manager case, the appellate court concluded that PSPRS, although it may not receive and deal with state monies, it does receive and expend public monies as a state agency and reference the same exact statutes that were reviewed by the ADOA court in finding that PSPRS is a state agency. PSPRS meets all of the state indicia of a state agency. It was created by statute. It's created to provide a uniform statewide program for public employees. Its board is statutorily allowed to commingle the assets of 3 retirement systems, PSPRS, the Elected Officials Retirement Plan, and the Corrections Officers Retirement Plan. And those assets that are managed by PSPRS include not only contributions from public employers and public employees, but also includes certain Supreme Court, Court of Appeals, Superior Court, and Justice of the Peace filing fees, as well as notary fees. It is managed by the Board of Trustees, as indicated, by members appointed by the governor pursuant to a statute that makes each of them state officers. And it's still subject to the sunset provisions, and it is required to transmit to the governor and to the legislature a comprehensive annual financial report by statute. It is required to permit the Auditor General to make an annual audit with the results transmitted to the governor and the legislature. The Attorney General is still the legal representative. The board is subject to open meeting laws and to the public records law. And in addition, although it is not subject to the Administrative Procedures Act, by statute, if it were not a state agency, the legislature would not even need to specifically exclude it from coverage under the APA.
Mr. Sullivan, I'd like to raise a question specifically about what is, in my version of the statute, subsection M, and counsel's statutory construction argument. It appeared to me that the plan agrees with the plaintiffs here that the version of the statute that was in effect before the, I think it's the 2013 or the 2012 changes,
Yes.
governs this, which would have, it listed the administrator, the assistant administrator, and all of that. The plan agrees with that?
I'm sorry, the plan agrees to that.
That is the version of the statute that is in effect here?
The one that's quoted by appellants?
Right.
Yes.
Okay. Forgive me, this is probably going to sound like a dumb question, but why are you agreeing with that? Why?
Why am I
Yes,
agreeing
why?
that?
Right.
Is in regard to the statute in effect at the time that they should have filed their notice of claim?
Right.
That was the effective statute? I'm not sure I understand.
Well, it just struck me that I would have thought, when you're in battle, you raise up a variety of arguments, but because the legislature amended that statute to eliminate all of that language. So if, in fact, they were attempting to say in 2006, this really isn't a public entity, it really isn't, they changed their mind, it looks like in 2012.
That's correct.
So, okay. So why, if they're just saying, okay, we've reevaluated this situation, this entity really is a state agency, and we really thought it was all along, but we want to clarify this. Why are you not arguing that?
Well, I think you make a good point.
No, don't
I
go
think
down
you
there if
make
you
an
haven't
excellent point.
argued it. It's okay.
I don't think the legislature has seesawed back and forth. You are a state agency. You aren't a state agency. Now you are a state agency. They've been a state agency all along. That has never changed. Any statutory language change has not affected the status of PSPRS as a state agency. And we disagree with counsel's distinction between exempt from and not subject to. Those terms mean the exact same thing. That argument is similar to the argument that was made by appellants in the SCF versus Superior Court case, in which the court ruled that an exemption of SCF from some requirements imposed on state agency does not exempt it from the notice of claim or statute of limitations under Title 12. By not exempting SCF, the court said, from Title 12, the legislature expressed its intent that it fell within Title 12. The legislature would not have enacted a statute expressly identifying statutes that were applicable to other state agencies but not to SCF unless it viewed SCF as a public entity. That's the same argument here. If the legislature meant to exempt PSPRS from protections under Title 12, the Notice of Claim statute, and the one-year statute of limitations, it would have so provided. Their attempts to distinguish, in addition, the Energy Corp case, which is the SCF case, by arguing there's a difference between exemption and the term not subject to is a distinction without a difference. For example, and I'd like to point out, in ARS 38-848, it says that the board is not subject to Title 41. They say not subject to means that they were removed as a state agency. But if you look at 38-848N, it states the board is subject to Title 41, Chapter 4. So they take them out of being a state agency in M and put them back into a state agency in paragraph N. That makes no sense. That creates an internal contradiction in the statute. Never intended to be that way, Your Honor.
Mr. Sullivan?
Yes.
Would you respond to the argument that the legislature must consider the system to be not part of state government because in 2006 it enacted an amendment that stated that the assets of the system are not subject to the debt limits that the state constitution imposes on state agencies.
Absolutely. Article 9, Section 5 is not applicable to PSPRS because it is not the state. And it is not applicable because it doesn't apply to special funds such as those that are administered by PSPRS. That section restricts the state from contracting debts exceeding $350,000. It doesn't define state, but in the context, state was not intended to include state agencies. The definition of state normally is a political system of a body of people politically organized or, by dictionary, made, maintained, or chartered by or under the authority of commonwealths making up a federal union. Those clearly don't apply to a state agency. Section 5 provides the state may borrow money to repel invasion, suppress insurrection, or defend the state in time of war. PSPRS is not going to do that. It's not the state for those purposes. In the context, it simply is not a state for purposes of that constitutional debt limitation construction. Contrary to the arguments made by counsel that this provision has been made applicable to other state agencies, and he cited the Long versus Napolitano case and the Board of Regents versus Sullivan case. Those cases involved, one, the TSA, which is very distinguishable from PSPRS because statutorily it is a corporate and political body performing a governmental function and with the rights, powers, and immunities of a municipal corporation. And therefore, it's similar to a political subdivision, not the same as a public agency such as PSPRS. Similarly, Board of Regents versus Sullivan, the Supreme Court found that the Board of Regents was a separate and independent legal entity from the state, and its obligations constitute the debt of the institution that issued them and are not a liability of the state.
And yet the Board of Regents, you have to serve a notice of claim on the Board of Regents. There are cases
Yes,
that say that.
That's correct. That is correct. So neither of those cases is support for their position. I would like to point out one other provision in regard to the exemption argument. The legislature has in the past interchangeably use the words exemption and not subject to. And I will point to a particular statute under Title 38, and that is 38-797-11. That statute relates to the Arizona State Retirement System, which is also subject to the Article 9 constitutional provision that is applicable to PSPRS. And in that case, that statute relating to a long-term disability program of ASRS is entitled as an exemption in the title, but in the actual language of the statute, it interchangeably uses exemption and not subject to. So the argument that those are two different terms is totally incorrect, and the legislature itself has used them interchangeably. I'd also like to point out the Rockland versus State case. That case specifically is instructive, although appellants have contended that it has no value, because it does consider the applicability of Article 9, Section 5 to PSPRS. That was the issue in that case. They didn't arrive at a decision in regard to that. But the appellants in that case had argued that the unfunded liability of the state under PSPRS was a debt under Article 9, Section 5 and 8, and exceeded the debt limitation of those sections. To overcome the presumption of constitutionality, the appellants had the burden of establishing, beyond a reasonable doubt, that the act violated some provision of the Constitution. But the court found that the provisions of Section 5 simply were not applicable to PSPRS, due to the definition of debt in that section. They also stated that the object of Section 8, Article 9 of the Constitution was meant to apply to acts of a political subdivision involuntarily becoming indebted, and do not apply to obligations and created and mandated by the state. And they stated, as thus construed, the constitutional section does not prohibit the manner of funding the pension system which the state has required of its political subdivisions. The court found PSPRS to be constitutional, and they found that provision not applicable to PSPRS. I think the weight of the case law, the weight of the interpretation, the weight of the analysis, and in the context of the statutes and how PSPRS operates and how the courts have found it to operate, it has to be found to be a public agency. I'd be glad to answer any questions you have.
Counsel, I noticed the plan system, filed a request for attorney's fees
Yes.
under 12-341-01A. How does this arise out of contract?
We had argued in the trial court that the allegations made against the system arose out of contract. And we had asked for attorney's fees in the lower court. The court did not grant them. We're covering our bases.
Okay. Okay.
Good answer.
Thank you.
Counsel?
Thank you. Very briefly, counsel raised the Mclean versus Pima County case and said that it was a case in 1993 that found the system to be a state agency.
Excuse me, counsel. Did you talk?
Think so.
Sorry.
I think I went 15 seconds there.
That's all right.
Add them.
That's
That's
all right.
okay.
In that case, the issue of whether the system was a state agency was not litigated. There was no dispute whether it was or it wasn't. The issue was, did a taxpayer have standing to challenge increases in benefit payments under various state retirement plans? The standing statute under which they moved said that any expenditure of public monies would confer standing. Public monies were defined as monies lawfully coming into the possession of the state agency. Based on the 1986 cases, the court simply assumed it was a state agency and no one argued otherwise. And that was that case. 2006 amendments are afterwards and made it clear it was not, and the 87 amendments to the statute were not discussed in that case. Second, the subject to versus exempt from language. I will simply direct the court to page 17 of our reply brief and to a lesser extent page 11 of the reply brief, where we cite to Court of Appeals decision saying there is a difference. And when the legislature chooses exempt, it means exempt. And when it says subject to, it means there's no power over them. There's nothing to exempt them from. And that there is a meaningful and material difference between the two. And then finally, as I heard my friend speak, I heard him saying what we talked about in my opening remarks. The system may contend it's a state agency when it suits its purpose, but if it doesn't, it won't. And here, if in fact it is a state agency for some purposes but not others, we would simply ask the court to look at the purposes underlying the notice of claim statute and conclude that for that statute, it is not a public entity. We respectfully ask that the decision below be reversed and the matter be remanded. Thank you.
Do you think the claim arises out of contract?
Your Honor, that was raised, litigated, and denied, and not appealed from.
Stand up, but they're asking for attorney's fees on appeal.
It does not, Your Honor. There is no authority that says the two claims asserted are aiding and abetting fiduciary duty and aiding and abetting fraud. There is no contract claim.
Thank both counsel for their arguments. We will take the matter under advisement and issue a decision in due course. With that, we stand in recess until the second oral argument. cases.
Remind everybody to please silence any cell phones, any iPads, tablets, laptops, anything that might make noise